Thank you for coming back. And just be aware, people are going to be floating in from lunch, so try not to get too distracted. But I'd like to thank you guys for actually making it back here at 1 o'clock. The next talk is going to be given by Samera Habib. And Samera's been practicing for 7 years, but she's got a depth of experience, life experience, which uniquely qualifies her to be a very empathetic divorce lawyer. Samera is a mom of 2 kids, and I asked Samera what she does for work, or for fun, and she says work, and then maybe work out a little bit. Samera's an extremely hard worker. Now, the talk she's going to give has been of special interest to me for many, many years. We try to discern what the best interests of a child or children are in these cases. Best interests is a subjective term, and subjective judgments are often a function of cultural background, education, intellectual background. For many years, and it's starting to change a little bit, but I think the parental responsibility evaluators and the lawyers and the judges would look at a situation through the prism of white American culture without recognition of some cultural differences. Samera's going to talk about some cultural differences involving Muslims and Jews and Sharia, and some other things. But the one example that I like to use to discuss cultural differences is what the Inuit do. The Inuit are the northern Alaskan natives. And in our white American culture, if you don't look somebody in the eye, something's wrong. Well, in the Inuit culture, if you look somebody in the eye, you're showing them disrespect. So what we can get a finder of fact or a CFI, or parental responsibility evaluator, who will say, well, why is that person avoiding eye contact with me? What are they trying to hide? And similarly, as lawyers, when we deal with our clients, we might have the same cultural differences which prevent us from understanding where they are coming from. So Samera has spent a lot of time with this talk, and she's got so much material. We don't know if we're going to have time for questions, but I know Samera, and if you have a question, she'd be really glad to answer it. If not in our session, then afterwards. I introduce Samera Habib.
Good afternoon. Thank you to Steve for that kind introduction, and to Mr. King for both of them giving me the opportunity to be here today. I am an immigrant to the United States. I immigrated at the age of 9. I am 35 now. I received derivative citizenship as a child after my mother was naturalized. And it gives me a great sense of pride in my naturalized identity and in my fellow Americans that you guys care enough about the cultures of people who are coming into your land and becoming one of you and trying to gradually adopt your ways over generations. And I really thank you for the time and attention you're giving this topic. One of the things that people think and assume when they hear about cultural issues in divorce is that this is boring. I don't want to hear how you're supposed to sit or dress or whatever in your culture. It's going to be one case out of 100 that I get, and I can just send that case to someone else and I'll be okay. But the truth of the matter is these cases are some of the most important and legally challenging that you will ever see in your practice. And the results are some of the most rewarding if you pay attention and if you actually understand that this is law. And today I'm going to try to condense a lot of material to bring some important topics to your attention. But these topics within the context of cultural issues and foreign laws and interjurisdictional problems and comedy and divorce and APR allocations can be branched on and expanded infinitely depending on what part of this topic you want to give attention to. Immigration law is federal law, and it affects state law outcomes. For example, if you represent a client in a criminal proceeding, you have to know his immigration status and you have to report that in your criminal case because it can severely affect what happens to your client and where he's permitted to live, which by proxy will affect his children and wife, etc. So, other things that in immigration law that affect state law are naturalization and immigration requirements to obtain visas. For example, when you're applying to immigrate to the United States, you have to report all of your legal affairs to America, and that includes entering into contractual agreements with the United States government. Part of those are criminal records, your marriage status, believe it or not, the marital status of your children, because they can get immigration status based on your immigration to the United States if it's awarded, your assets, your level of education, and how much money you have in your bank account. So all these things translate into a written and sworn affidavit that you're representing to the United States government. So if immigration, which is federal law, affects state law outcomes so much, why not consider the ramifications of marriage, divorce, and custody outcomes that stem from foreign countries or that stem from the United States when we are dealing with our internal Colorado dissolution of marriage and allocation of parental responsibilities issues? And I'll give you some statistics to highlight why this issue is so important. According to the Migration Policy Institute, which is an independent, nonpartisan DC think tank, in 2015, 20.7 million immigrants were naturalized. That means 20.7 million of us became your fellow Americans. And we carry on that citizenship derivatively to our children that are born abroad, and we can pull in people from foreign countries as our spouses, aunts, uncles, cousins, even if it happens 20 years down the line. That left only 22.6 million remaining legal and illegal immigrants. So 48% of immigrants in America became Americans in 2015. When considering that, think of the fact that Colorado has a population of about 5 million people. So you are talking about a group of people more than 4 times the population of Colorado becoming our fellow Americans and bringing international, jurisdictional, family, business, etc. issues into our country and into Colorado because part of that immigration population is from here. Some of these people have spouses who are not yet citizens. Some of these people have dual citizenship. And some of these people become expatriates. That means they leave the United States to work abroad, whether in their mother country or not, but they still remit taxes to the United States or they leave families behind in the United States. This becomes of particular importance in Colorado family law when we understand that some of these nations bind these citizens by laws that do not recognize a separation of church and state. So to a certain extent, when dealing particularly with Muslim and Jewish families, the separation of church and state is absolutely inevitable. And that's a conundrum that we all have to deal with. The materials are out of order from my lecture, and part of the reason I don't have PowerPoints is I always change things last minute. I just go with what I feel at the moment. But these are things you can link, these are things I'm gonna say that you can link back to your materials. There's an article called Chipping Away at the Divorce Quagmire for Muslim and Jewish Women. And in this article, the New York State courts offer a very interesting and novel solution to religious divorce issues in order to give relief to citizens. And here the primary issue is Jewish females who can file and obtain a legal divorce in the state of New York but cannot get a religious divorce. And I will tell you why this is important. Without a religious divorce, a woman is religiously changed to her husband. Despite obtaining a civil divorce, a woman must obtain a religious divorce to remarry. If a Jewish woman remarried without a religious divorce, she is considered an adulterer. As a result, her children born out of this relationship may be considered illegitimate with serious religious consequences and legal consequences ranging from inheritance eligibility to remarriage restrictions. And as you can imagine, that can create ramifications to how a subsequent spouse or children from a subsequent marriage can inherit. So it becomes very legally relevant. Additionally, in the Muslim context, without a religious divorce, a woman cannot remarry. If she remarries, her marriage will be void and she will be committing adultery. It gets more interesting. With a Muslim woman's marriage still subsisting, her former husband will be considered the legally surviving husband entitled to inherit. This is of particular interest for dual citizens. This situation is even more complicated for Muslim women who marry abroad or continue to visit their native countries. For example, several Muslim countries subject wives to travel restrictions. So what do you do if you divorce a Muslim woman and she goes back to a home nation where she's a dual citizen, that does not recognize the American divorce? You have an APR order that says she's entitled to 50-50 parenting, and now she can't come back because her husband in the Muslim nation has imposed a travel restriction that will not let her return to this country. How do you deal with the children? How do you deal with best interests? And how do you address these issues to the eyes of the court? And more interestingly, can an American court compel the husband to lift that travel restriction in a foreign country? Or can an American court hold him in contempt in America for breaching American law by reaching into the foreign country and exercising his right as a dual citizen there, albeit he's an expatriate? So as you can see, this can get really, really, really complicated. New York finally found a solution in a case called Lowy v. Lowy in the New York Appellate Court, and it was issued in 2011. They found that a final divorce judgment can incorporate a rabbinical court decision in a dual final divorce decree. And what they used to avoid the long historic problem that New York has struggled with of mixing church and state is they found this based on an implied contract theory, which means the interpretation of the Jewish laws can be contractually rolled into an American divorce decree and therefore avoid the whole religion question altogether. Interestingly enough, in Ohio, a state just a couple of states over, it's not recognized. This is deemed unconstitutional per a case called Steinberg v. Steinberg that was issued in '82. So while different courts, the highest courts of different states, have addressed this issue at different times, there's no uniformity, and this issue has not yet made it to the United States Supreme Court. And I hope it's one of us here today that gets that case there and gets a final decision that creates uniformity. I'm going to present you with a complicated fact pattern. Our characters are husband, wife one, and wife two. Husband and wife one get married in 1970 in Israel. A court in Ohio found that the marriage contract is a valid contract documented by a Palestinian authority. In 1970, that same year, they both moved to the United States. Between 1982 and 1985, they have 4 children together. In 1992, even though husband and wife have been residing in Ohio all these years, husband flies back to Israel for a short period of 3 weeks, not enough to establish residency there. He travels there and without his wife's knowledge gets a divorce decree, an ex parte divorce decree, which is arguably legal under the court that he obtained the decree in. In 1995, he marries wife number 2. He registers that marriage with the county in Ohio. In 1996, he signs an affidavit stating that he married wife number 1 in 1970 and that he divorced her in 1992 prior to his 1995 marriage to his second wife. Wife number 1 becomes suspicious that he might have divorced her. She interrogates him and he says, "Absolutely not. I love you. You're my wife. She's just the side woman." And she moves under that assumption. And from 1993 until 1995, husband and wife number 2 filed joint tax returns holding themselves out to be married to the federal government. In the year 2000, the husband was fatally shot. The issue here is, who is the surviving spouse? Not even a family law case, everybody. It was not even litigated on a family law basis, but the marriage laws and the divorce laws carried over. So in 2000, wife number 1 flies back to Israel, mad as you can imagine, and she requests documents indicating that her husband remarried her in 1992. And this would involve some knowledge of Islamic divorce and marriage laws. Islam proposes that there are 3 total talaqs, or divorces, permitted. Only the husband can issue them, and the first 2 are revocable. And the way you revoke this divorces is by taking the wife back into your bed. So she flies back and says, "Look, he took me back even if he divorced me. I need a document." She obtains her document. In 2000, husband's son, we don't know who his mother is, he files something with the court requesting a determination of the heir, the proper heir, wife 1 or 2, for several convenience stores and livestock businesses that the husband owned. The lower court in that case held that the 1992 divorce in Palestine, the unilateral ex parte, lack of due process divorce, is valid and declares that wife number 2 is the surviving spouse. So for anybody who knows Palestinian women, wife number 1 was not going to have it. She lifted up her sleeves and she headed down to the Court of Appeals and she did what she had to. And the Court of Appeals held that Ohio does not give comity to foreign divorce decrees when the parties involved don't live in that country. And that's, albeit out of Ohio, it's a great rule to rely on if you ever face that situation here. And when we don't have those laws in Colorado and those cases, we can refer to cases from equal jurisdictions. People cannot forum shop. You cannot divorce your wife or your husband in a country of dual citizenship to obtain a better outcome. And it's funny that people struggle with this issue all the way up to appeals court. And it's funny that the lower level court struggled with it because it is the basic argument of forum shopping, which we all learn in law school. The court further held that without evidence of foreign residency requirements, what are the foreign residency requirements in Israel? Ohio assumes that Ohio's residency requirements apply. And that means the UCCJEA, and that means Ohio's 6 months residency requirement leading up to divorce. The parties did not reside in Ramallah in Israel, possibly Palestine at the time, 6 months prior to the divorce. Therefore, the divorce is not valid. Wife number one is the surviving spouse. Is that complicated enough for everybody? That was.
I thought the real issue is why it took so long for the husband to get shot.
It's hard to recover from that one. Like I said, I know Palestinian women, so. One of the issues that.
I'd like to say something.
Yeah.
I've got a question and a comment.
Absolutely.
What Samera is talking about is not theoretical. There's a case in Colorado called Popak. And Mr. was a rabbi, very religious, and Mrs. was part of the program. Very religious community in New York. There were like 10 or 12 kids or whatever. And in Judaism, there's a rabbinical court, and it's called the Beit Din. And they were of this culture, and so the wife decided to submit to the jurisdiction of the Beit Din, which is the religious court. Well, the religious court is extremely patriarchal. And she went to try the case, and she really got hammered. So she attempted to file a divorce case or to prosecute the civil case in saying the pronouncement of the religious court was not valid. Went up to the Supreme Court. And the courts held that the wife's commitment to participate with the Beit Din, the religious court, and to subject herself to jurisdiction was an arbitration agreement. And one of the things that are going on with the courts, and it's been for years and years and years, and it continues, is there's not a lot of money to defend the courts. So if there's any way a judge can get a case off of his or her docket, that's what they're doing. So you've got to be careful about not subjecting your clients to a religious court without them understanding that it's going to be a little different there than it would in a civil case. So that's just a comment. And I have a question, too.
Yes.
Comity is full faith and credit to foreign judgments, so to speak. Mm-hmm. But isn't there exceptions to the comity rules when we are just so disgusted by what's going on in some other country?
Yes.
And how does that work? I mean, is there such an exception, the disgust exception?
Yes, that is a great question. And the doctrine of comity, well, there's our doctrine of comity that's in the United States Constitution that says the states will give each other full faith and credit. But the issue with that type of comity, which is inside the United States, is that it's reciprocal and the reciprocity is guaranteed. It binds all the states equally. International comity doctrine is a little bit different, and that is in a case I will reference later in my materials that stems from 1895 from the U.S. Supreme Court. But comity with foreign nations, number one, is heavily based on whether or not that nation would give comity to U.S. court orders. And number two, does giving that foreign law or that foreign case or that foreign court order result in a contravention to American laws? And if an order issued out of a foreign jurisdiction contradicts local United States and Colorado laws, that order is struck down and it does not get comity. And also, an order can be struck down under the old international doctrine of comity if it not only offends the laws of the nation and the jurisdiction we're in, but if it offends the laws of nature and God, and that's the discussed argument that Steve is referencing. Yeah.
I knew it existed somewhere.
So one of the first issues that comes up, and I thought of this because my firm actually dealt with this in a case, and these cases get kicked back for appeals for something very silly such as service, and it can take, instead of a year or two to determine a divorce case, 6 or 7 years, and this has actually happened in various cases. Service, when you are dealing with someone who, even if they're a United States citizen, if they live overseas, or if they've expatriated, or if they established even a temporary domicile overseas that contravenes our local residency requirements, or if they're just visiting overseas, you have to serve in a manner that not only meets the standards of United States laws, but it also has to meet the standards of that jurisdiction's service. Otherwise, it can be struck down. So the first thing you need to do if you get a case that involves a party in a foreign country or somebody who's absconded to avoid service is you have to enlist the help of a lawyer in that jurisdiction to ensure you are doing things correctly in that country. That's essential. And it's on you to make sure that's a competent lawyer, or to leave it to that person to choose a competent lawyer and sign some form of waiver that says, I picked my lawyer. That foreign lawyer has nothing to do with malpractice on my attorney's behalf here in the United States. You can serve in conformance with a treaty if a treaty exists, but service based on a treaty with a foreign country is very tricky. This is under the United States constitutional law, and it requires jurisdiction-specific research. So you would have to read that treaty inside out to make sure you're complying with every term. You must make sure that the compliance with the treaty works in your local clerk's office as well, and works in the foreign country. Some of these treaties require service in that foreign language. So if you don't speak Arabic, you need to find an interpreter who can translate these documents accurately and certify them and get them certified in that jurisdiction and file them there. The Hague Convention provides different ways to serve internationally. One form of service is called letters rogatory service, and it's a method that requires collaboration between courts. So the court in America calls the court in a foreign country, and they collaborate, and that requires filing in that foreign country. That would absolutely require an attorney licensed there to draft the proper petition and get it filed on your behalf and corroborate with you, and that's kind of tricky. The most reliable form of service, which is provided for under the Hague Convention, is called a service by central authority. It's also provided under the Hague, and it's a local government authority, such as the police, that would serve. And you would need local counsel there to ensure you met the legal requirements, because the police cannot practice law. You can do something called a service by agent under the Hague Convention. It is very similar to service in the United States, but you must look at the local service rules to ensure that this form of service is locally permitted. So the attorney you're working with has to be very trustworthy. I'm not saying this to discriminate, but clearly an attorney in Switzerland is going to be much more capable of determining the laws than an attorney in Libya, for example, where they're experiencing the Arab Spring, and these laws can be challenged because there is no valid legal system there at the time. Service by publication and waiver can be permitted, but they are very tricky. So I would advise trying service by central authority and consulting with a local attorney and making sure you have your documents in the correct language. If it is not served properly, your case will get kicked to the Court of Appeals, and even though the findings are correct, the party who is not served properly can get the case relitigated, and that could mean learning from their mistakes the first time around. In terms of recognition of a foreign divorce decree, this goes back to what Steve said. The doctrine of comity states, international comity, it's the extent and obligation of the laws of one nation within the territories of another. So it would be if I file a divorce decree against a Lebanese citizen and we have orders there that are stemming here, it would be the laws of Lebanon exercised in the United States. So it could be quite complicated. It's a legal justification for the resolution of conflicts of laws problem, and a court in one country may apply the laws of another country by virtue of comity, as resolution to conflict of laws is a huge problem that we deal with in these cases. The primary case that you can read to understand international comity is Hilton v. Guyot, G-U-Y-O-T. That's a United States Supreme Court case from 1895, and again, this doctrine has exceptions. In a case that's in your materials called Fuad versus Megdi, and that's a New York Appellate Court case stemming from 2017. Dina, who's the female, and Amr, who's the male, got married in Egypt, and they were Egyptian citizens, and they had 2 children there. They came to the United States in 2012. In July of 2015, 3 years later, Megdi has an affair and he sends his wife over as a temporary respite from their marital discord, telling her that the best way to reconcile is for the children and her to be away from the stress of the affair and to be with her family in their homeland just to experience some peace so they can reconcile. This was in July 2015. 3 months later, in October of 2015, Dina files for divorce in New York because she understands Megdi is just tricking her, he's forum shopping, and he does not intend to bring her back to the United States. She asks for resolution to everything in the case, issuing the divorce, APR, property and debt division, etc. Just a few days later, about a week later, Amr seeks a divorce by proxy in Egypt, which is permitted under Egyptian law. But here, the issue is we have an Egyptian and American immigrant living in America. His domicile is America, but he's exercising his right as an Egyptian citizen to divorce by proxy. And divorce by proxy is a really weird creature of some laws in Muslim nations, which is you call an official and you say, I give you permission to divorce my wife, and that person who's never met you or your wife divorces her in that country for you. So the divorce by proxy was issued in Egypt, and it was perfectly legal under Egyptian law. Dina was not present or notified, and that is a very key factor here. Amr's clear intent was to circumvent more favorable New York laws to Dina. There's no doubt about that in the finding of facts. So Dina alleges in the divorce that she filed in New York that the Egyptian decree is fraudulent because she wasn't there. The New York case was filed first, and this is really important. This is like a no-brainer for all of us. And that the divorce was not final as Egypt, this is the first, second, third divorce, remember? The first and second divorces are revocable, and the third one is irrevocable. So she says this is not a final divorce because she's still within the first two irrevocable divorces under Egyptian law. She provided ample evidence to support her position. The trial court granted Amr's motion to dismiss the New York case because they said the parties are already divorced in Egypt. Now remember, a divorce by proxy in Egypt does not require resolution of the APR cases, of the debt, of the property, of spousal maintenance. It just says you're divorced and poof, get away from the court. So that divorce was issued very quickly. The New York court found that because they're divorced in Egypt, she doesn't have a right to a divorce here, and that case was dismissed. She appealed to the New York Supreme Court Appellate Division, who reversed, and here's what they found. We reject the husband's contention that the doctrine of comity mandates dismissal of the wife's divorce action. New York's first in time rule provides that the court, which has first taken jurisdiction, is the one which should determine the matter. Now, we've had an Ohio court and a New York court both address jurisdiction being proper, but they use different reasoning. One court says that if there's no proper jurisdiction in the other nation, and if the parties don't reside there, based on Ohio rules of jurisdiction, Ohio rules reign. This court in New York comes to the same conclusion, but uses different reasoning. They say it's whoever files first rule. So the court struck down the husband's forum nonconvenience argument. And here's what's interesting about it. Even though they live in New York, he argued that New York is not the convenient forum. And part of me is like, why didn't her attorney assert that? That would have worked brilliantly. But the court found that New York is convenient due to nexus. They live there, their children are there. It doesn't matter what their citizenship status is. New York is appropriate to determine APR and financial issues, even if the Egyptian divorce decree was valid. And now we have branched off to a whole other legal issue. What if the divorce is valid in Egypt? What happens to all the other issues? And I have tried a case based on Libyan law that dealt with the same thing. In my case, the divorce decree was not challenged out of Egypt. My client out of Libya. My client admitted that the divorce decree is valid, but she challenged the lack of issuing of orders on all the other issues, and the court in the 18th Judicial District heard that case and awarded the appropriate orders. Yes?
You and I discussed this before just a little bit. I had done a comity case in Jefferson County regarding a husband trying to enforce an Iranian divorce decree, and we had an all-day hearing on that. But the ruling from the judge, which didn't take too long, wasn't based on who was first in time, first to write, or any of these procedural niceties. He simply applied comity and on a brief said, if the law that's trying to be applied is contrary to the public policy of the state here. So it seems like this is a lot of procedural back and forth, but if you get right down to the bottom of the merits of it, what we're talking about is something that's contrary to the culture of the United States, I guess as a general rule, regardless of where it's from. Is that your understanding of this as well?
It's my understanding in regards to the exception to international comedy. That number one, exactly as you stated, comedy has to be reciprocal, right?
Yes.
So in your case, if that country did not recognize it, that's a tier one argument. But what if comedy had been reciprocal? Then you have to go to the second tier and the second prong, and you have to say, well, is it offensive to our laws? Does it contravene our laws? If it doesn't contravene our laws, you have to go to a third prong. Does it contravene our public policy? And that's where consultation with people who have an expertise in these cultures, albeit not necessarily laws, is very important, because they can shed a lot of light, and that can be in the form of going to religious members of these various communities. The problem therein with arguing public policy is a lot of these religious people will lie because they feel that they have a duty. They come from a country where there's no separation between religion and state. So you can't say, well, you're not really religious. How could you push that on us when you're not practicing? They are practicing if they live in those countries, because those are their laws. And you can go to a mosque, and that's based on my experience, and you can ask an imam, well, is it true that the husband can do this to his wife, can divorce her without due process? And he will lie to protect his faith and his nation, as he is mandated to do religiously. So that's where the public policy argument can get really factually tricky. Another thing that members of these communities will do, particularly on behalf of women, is they will refuse to produce witnesses to support their facts. The Quran clearly states that whoever withholds testimony from God is sinning against God and is an enemy of God. But people ignore that verse, and they justify it under the umbrella of protecting their faith as a whole. So as a culture, we have a tendency to try to project our faith and our cultural practices in a better image, because we want white people to think better of us. We want to make you guys think that we're very upstanding, and that could involve lying to the court. That's why I hesitate to rely on a public policy argument purely, because then I'm going to have to present a lot of witnesses on whether or not the public policy of that country does contravene our public policy here. If that makes sense. Okay. So in a case called Aleem v. Aleem out of Maryland in 2008, this is the Maryland Court of Appeals, the parties were married in Pakistan. And what I want to highlight here is, as we get through the cases, you're going to see how the various arguments contradict. They were married in Pakistan. They lived in Maryland for 20 years, had no primary residence contact with Pakistan. Husband divorced his wife via a triple talaq. So he went and he said, I'm going to give you all three at once, so it's not revocable. In a Pakistani embassy in the United States. This gets really creative. Now, his reasoning was that they were married per Islamic law, so the triple talaq is irrevocable. And that's the only form of divorce they're entitled to, because the marriage is Islamic. So he's saying we weren't married under secular laws. He said the Maryland courts are not Islamic courts, and they have no jurisdiction over his marriage. I'd hate to be the attorney who made that argument. So the wife's reasoning in her defense was, we've lived in the United States, we have a divorce pending in the United States courts that I filed, and the US courts have the ability to divide the property that's here in the United States. A Pakistani embassy can't do that. It wasn't even before a court, it was before an embassy. And that raises to the question of how much authority does a foreign embassy here in the United States have to intervene with local state laws? This is state law, and an embassy is under some kind of federal umbrella. So the court says all this, husband, wife, attorneys, all of it is irrelevant. And I'm going to tell you why. Because talaq, or divorce in Islamic law, denies the wife due process. We finally have a court that goes back to the foundational law of our country, which is the United States Constitution. Both of your arguments and your counsel are irrelevant. This denies wife due process. This wholly conflicts with state and federal laws, and as such, Maryland courts should not give credence or comity to Pakistani Islamic statutes. Does that help with the earlier question? Yeah.
Is that substantive discussed or procedural discussed? That's procedural discussed.
Yeah.
It's just, it offends our notions of due process.
Yeah. And it just gets so interesting how, because we have no federal laws to resolve this issue of different jurisdictional relationships with the United States and foreign jurisdictions, we have states trying to get creative to get to the same common sense argument. And it leaves it up to all of us to decide what we're going to argue and what a Colorado court is going to listen to. Another case is called Hussein. This one is with an A, not an E. The fact pattern that I repeated to you was the Hussein with an E out of the Ohio Appellate Court. This is Hussein with an A in 2016 out of the Ohio Appellate Court as well. So here, the husband alleges, the first guy says in Pakistan, the Pakistani married couple who live in Maryland, the husband says, we're Islamically married, so we can only be Islamically divorced. Maryland, you can't divorce us. This guy takes the argument, I think, to like a whole new level of illogical. He says, I'm not really married. I got married in India, and therefore that marriage is not valid here. So, the trial court found that the marriage is valid in India and as such is valid in the United States, but doesn't really explain why. It says there's no separation of church and state in India, so the imam's marriage in India is valid in the United States, and that gets really convoluted. In the appellate court, the court references Mazzolini v. Mazzolini, Mazzolini, which is a 1958 Ohio case. And they finally get to a basic contractual principle of our law called the lex loci contractus. And they say generally, the validity of a marriage is determined by the lex loci contractus, which means the law of the place where the contract is made is the reigning law. So now we have left due process, we have left comity, and now we're talking about basic contractual principles. And to make this more clear, we get out of the marriage contract situation and out of the fact that these parties, if the attorneys had thought about it, are immigrants, and they represented, and so did husband, on his immigration documents, that he is married. That was a requirement for him to immigrate here. And now he's contravening a document and an application where he swore to the federal government that he's married. This could disqualify him from his citizenship, arguably, if he obtained it, or can possibly get him removed because he lied to a federal government. But nobody thinks about these basic foundational elements of how somebody attained citizenship here or how they immigrated. And we have a basic contractual argument that says, for example, if I enter, let's talk about widgets again, contracts class. If I enter into a contract to buy widgets in Lebanon and I execute that contract in Lebanon and I come to the United States and I breach that contract, what laws will bind that contract? We all know the answer is Lebanon. So why should it be any different for marriage and divorce law? It shouldn't. We just have to kind of get outside of the divorce box and think about these things.
Can I respond to that?
Yeah.
We're not dealing with widgets. We're dealing with kids. And the state, as parents patriae, has a different role vis-a-vis those kids than they would with respect to a widget. So I think I disagree with you saying it's common sense. It's going to be under Lebanon law.
But there's a distinction, Steve. And the distinction here is that the case has not made it to the APR phase yet. They are challenging the basis of whether or not there's a marriage. And this is not in regards to the children for APR, because you don't have to be married to address issues in APR. This is in regards to the one thing that men generally from these jurisdictions do, which is try to forum shop to pick the forum that gives them the best financial outcome. I see this case as being purely in regards to maintenance and property, and he's saying she does not get any under divorce law because guess what? We were never married to begin with.
But I guess my question is, let's assume we are at the APR phase. We want to honor the Lebanese contract, but let's say the marriage contract said that the kids are going to go to the paternal grandmother or whatever, okay? Is it your opinion that that provision of the Lebanese marriage contract is going to be applicable to the United States?
Well, I guess I'm not sure why there would be a parenting plan that's contractually entered into in Lebanon if the United States has jurisdiction. I only foresee that being an issue if the family moves here after the APR is concluded in Lebanon and then somebody moves to modify. But in that case, we have a registration of a foreign decree.
So we have a Lebanese contract, a marriage contract, and it says A, B, C, and D, and if we have kids, this is what happens with the kids. It goes with dad, who's a ne'er-do-well. Okay. They're both in the United States. However, my understanding is the marriage contract will be construed under Lebanese law, even in the United States. Correct?
In regards to the marriage,
In regards to the marriage. So my next question is, what if the marriage contract includes onerous terms for the children? Is that going to have to be honored, or do we get the exception to comity there?
What's interesting about that question is that even a prospective parenting plan entered into in the United States would not be honored by a United States court because it contravenes the best interests of the children. For best interests, even if the contract was drafted in the same jurisdiction, you have to look at the children now. It's much like the issue of maintenance when you're looking at a prenuptial agreement.
Mm-hmm.
Yeah.
Okay.
So what we get out of Hussein v. Hussein is 3 different points. Number 1 is that if it's valid there, it's valid everywhere in regards to a contract. Number 2, if it's void there, it's void everywhere in regards to a contract. And number 3 is that there's a comity exception. Agreements of the parties, contractual agreements, will not be held valid in a foreign country if it violates the laws of that foreign country, the laws of nature, or the laws of God. Think about things like polygamy and dowry contracts that deny support. So in some countries, one of the precepts and one of the requirements to even be legally married is to offer a dowry that's 2-pronged. One element of the dowry is an upfront payment to the wife to prepare her for the marriage and to prepare for her financial needs for the marriage. The second aspect of the dowry is, if I divorce you, I'll pay you $50,000. And a lot of Muslim men present that to the court to argue that that is a prenuptial agreement in regards to maintenance and property division. And some Muslim women present it to the court because they say, you know what, you messed with me for 20 years. I want my maintenance, I want my property division, and I want the $50,000. And I haven't seen it work for anybody. I just don't have law on that right now. In regards to polygamy, that's the other example. Think of polygamy as, for example, that is permissible in countries, even in countries where it's against public policy. In Lebanon, polygamy is against public policy, but a lot of Muslim men exercise it under their religious laws. Interestingly enough, in Lebanon, Christian men can't exercise it because Christianity doesn't permit it. So it's a subjective kind of rule. If somebody brings a valid polygamy contract to the United States, we're not going to honor that. That's offensive to our conscience, to our public policy, to everything. So there's a lot of other stuff in the materials that I will leave to you to read, but I would like to take you to the last page of my outline. We have about 5 minutes where I'm going to put some interesting questions before you. It's page 5, and I'm looking at 12 and 13. And these are some scenarios I want you guys to think about. We have a common law question. What would happen if a party testifies that she intended to be religiously married? Let's say she's Jewish or Muslim, and she intended to be religiously married to her husband to avoid being socially shunned, to avoid detrimental inheritance laws, to avoid allegations of infidelity or not infidelity, adultery in that religion and in that church, and because her ethnic community just will not use the word boyfriend. It just doesn't exist in that community. And so as such, they held themselves out to be married. They had children together. They shared a home. They shared finances. But they never legally registered their marriage, and they never filed joint taxes. Who has thoughts on whether they're married or not?
They're not married.
They're not.
They're
Can you tell us?
You have to have intent.
Intent, yeah.
You have to have intent to be, quote, use the words, legally married. You're saying I'm doing this as a sham because it looks good at parties. That's not going to cut it as a common law marriage, in my opinion.
There's an argument for marriage by estoppel. It's not a good argument. It's not a good argument, but there's an argument.
Is that one you just made up? Right?
Yeah, I just lost that one.
And the reason for that question is when you guys get that client, you know the attorney to send them to now. So I have not seen it litigated. I've seen it a lot in consultations. It has just never gotten to that point, and I have no case law on it. But in a state, the reason I ask this question is because we are in Colorado, and we do have common law. And what happens in that case, especially, does it change as the duration of the marriage changes, or is the duration of the relationship? Is it different if they're together 2 years versus 22 years? The next question I have is something I presented to a court, and I'm happy to share with you guys how the judge resolved it once you guys try to answer. So a father lives with his parents and extended family in one home. This is how the couple lived during their marriage, with his family and his extended family. Now, in an APR proceeding, the mother claims that she should be the primary residential parent with majority parenting time because the children have more space and privacy in her home and are not dealing with the intrusion of the extended family. The intrusion of the extended extended family is abnormal in American culture. She's American and she should not have to subject her children to the cultural norms of their father. Added to this is father has been having financial difficulty, and there was a very short period where he lived outside of his parents' home. Should the court listen to husband's financial difficulty and cultural defense argument, or should they listen to mother's, and he wanted 50-50, or should they listen to the mother's argument about father's culture being too invasive on the children's privacy? Anyone have a proposition? Yes.
I'm not a family law attorney at all, but I mean, maybe it's actually more supportive for the children to be in that family situation where they're surrounded by more relatives. What's to say that what's normal in our society? I mean, we have, high mortality rates and whatnot. What's to say that the way we do it is actually psychologically better for the children?
And that's what I presented as part of it.
And you know what, there's another, and it's more local. A lot of Hispanic families have a different concept of the extended families and different purpose of extended families than white Anglos. In the Hispanic culture, the abuelos and the abuelas and the tias and the tios, it's all one big happy. Whereas, white Northern European type of Christian people might be uncomfortable by the seeming chaos of an Hispanic home. So the cultural differences and anomalies do play out every day.
Well, in this specific case, I presume by names and appearances that this judge happened to share some of this cultural background. And he asked the father a very specific question about his financial difficulties, and the judge found that the cultural argument would have been very amazing if dad wasn't suffering financially, and the judge is more prone to believing the financial stress argument. So we didn't really win on that. I have one last question. So you have two parents who are illegal immigrants. They're sharing the child 50-50 and they need an APR, but now they're struggling with figuring out a schedule. The father retains you. He's under removal supervision by the Department of Immigration and Naturalization, but he's not in active removal proceedings. He has a substantial relationship with the child who loves him, but there's really no certainty on when removal proceedings, which is a trial to deport him, would begin, and if that would take months or years. The mother is also an illegal immigrant, and she could potentially be under removal or deportation scrutiny in the next coming years. What is in the best interest of the child in regards to parenting time? Do you sever the child's relationship with his father now and limit it because the father can potentially be removed in the next 2 or 3 years, which would harm the child? Or do you harm the child by exposing him to a lot of love by his father, and then the federal government rips his father away?
I think that's an easy choice. Go ahead.
Yeah, I would let the father continue to have the relationship as long as possible, because that creates more of a bond that might continue to be deeply important.
I agree. And one of the things that I learned is that is a proceeding you have to disclose in the petition. Thank you all for your time. It was an honor.
Folks, that was excellent. Samera, thank you. We're all thinking outside of our little boxes now, and we understand that it's a big world out there. Okay, now we're going to do something completely different.